Next lesson is 11. Indemnification and defense obligations can be costly. The first case is National Union Fire Insurance versus John Zink. It's a Texas decision, 2010. And this is one where the court found that indemnity, limitation of liability, and insurance can all be tied together and a claim release by the contractor enforced. Here, there was an EPC contract for a refinery, and it required the contractor to have a CGL policy, and it limited the design builder's liability to an amount based on insurance proceeds. There was a release and waiver provision that stated that Valero Corporation would, quote, release, defend, indemnify, and hold harmless, close quote, the contractors to the extent insurance did not cover the loss. This is somewhat unusual in that the contract was not actually executed until after the work on the project was completed. They had been negotiating back and forth. There had been a long-term battle of the forms. They couldn't come to agreement, and it wasn't until the project was done that they ultimately signed the contract. Now, there were unrelated explosions due to different design builders' products. And these explosions occurred 2 and 3 years after the contract was executed. Valero and its insurance carriers argued that because the limitation of liability, the waiver, and the release was all part of a contract that was executed prior to the explosions, it did not apply to claims for damages from the later explosion. So in other words, they're arguing that, look, at the time the release was signed, the explosions had not yet occurred, therefore it couldn't apply to those. The court held, since the alleged negligence of the contractors was on work that was performed prior to the waiver release being signed as part of that executed contract, the damages arising out of the negligent work was in fact released, even though the explosions and the damages had not yet occurred. What matters is when the negligence occurred, not when the damages materialized. In deciding to enforce the release provision, the court explained its reasoning as follows, quote, Valero and Kellogg are sophisticated entities, replete with learned counsel. They negotiated their working relationship over the course of almost 3 years, with Kellogg submitting several proposals for Valero's review. Valero, having bargaining power equal to Kellogg's, agreed to the exculpatory clause in this contract. Valero possessed resources necessary to ascertain and understand the rights it held. Valero, of its own accord, negotiated those rights away. Close quote. The next case is one involving Union Oil versus John Brown. And this is another interesting limitation of liability being enforced. The LOL clause here in a design build contract limited the design builder's liability to $332,000. This was to its client, Unicom. And this would apply to breach of contract damages, where the client claimed that an 8-month delay in the project completion was caused by the design builder's failures. Unicom argued that this should be an unenforceable LOL clause, but the court concluded that Unicom was experienced with such contracts and voluntarily acquiesced to the limit of liability clause, that Unicom was, quote, a giant and sophisticated company, close quote, and there was no evidence of an unequal bargaining position. So again, the court looked here at the bargaining position between the parties. They're both commercial entities. The amount of the LOL was not nominal. So for a number of reasons, the court found that the LOL was enforceable. Now let's look at a case where the court found the limitation of liability could not be enforced. First, we know that a waiver of damages must be clearly stated. Where a contract was found to not have specifically imposed a limitation on the available remedies to the project owner or expressly waive the owner's right to recover consequential damages, the design builder was held liable for the owner's lost revenue during a 3-month shutdown that was caused by catastrophic failure of a steam turbine. The design builder acknowledged that the equipment failure resulted from defects in its design, material, workmanship, or installation, but it argued that it complied with its contractual obligation to repair or replace a defective part, and that this obligation did not expressly include consequential damages as a potential liability during the warranty repair. The court rejected that argument. The next case is William Graham versus Cave City. And in this case, the court addressed the question of whether the limitation of liability clause applied to all conceivable causes of action, such as breach of contract, negligence, misrepresentation, etc., or only to the specific type of claim designated in the LOL clause. And what we're going to see from looking at a number of different cases around the country is you have to be very careful in crafting your LOL clause that you specify that it applies to every conceivable cause of action. So in this case, the court construed a clause that read as follows, quote, "The owner agrees to limit the engineer's liability to the owner and to all construction contractors and subs on the project due to the engineer's professional negligent acts, errors, and omissions, such that the total aggregate liability of the engineer to those named shall not exceed $50,000 or the engineer's total fee for services rendered on the project, whichever is greater." Period, close quote. The court read that to bar only negligence claims and not those that were based on breach of contract. The failure of the AE in this case to timely submit plans to the government agency resulted in the loss of grant funding to the municipality, and the court found that to be a breach of contract and refused to limit the damages to the amount that would have resulted under the LOL, which would have been $99,000. Next we go to Lesson 12, Designer's Liability to the Contractor. First case is Mudgett versus Marshall. A design builder contracted to design and fabricate a storage facility. It subcontracted the steel design to an engineer. The engineer had miscalculations in its design, and this caused a structural collapse. The engineer was liable for the injuries because of its duty to create a design imposing no unreasonable danger to those implementing it. So in this case, the engineer could have direct liability for its defective design. The next case is Maddox versus the Benham Group. And in this case, the design professional breached an implied warranty that its design was sufficient to enable the contractor, its prime, if you will, to adequately price and bid the project in its design-build proposal. The contractor relied on drawings and specifications that were prepared by the AE per an oral contract. There was no written agreement at this point, not even a written teaming agreement apparently. Nevertheless, the contractor was able to recover from the designer for its losses. The next case is Skidmore, Owings and Merrill, and in this case the contractor relied on the design professional's drawings in preparing its guaranteed maximum price that was going to be a part of its proposal to the owner. The drawings had major defects that required substantial changes, increased the project cost, and caused delay. The AE was held liable to the contractor for those costs. Let's look now at subcontractor relationships. What is the duty of the design builder, the prime contractor, to its subs? There are certain notice requirements in every contract. We've talked about those in one of the earlier lessons that we discussed. But the notice requirements for changes or claims must be strictly followed. And a sub was precluded from recovering on delay claims because it failed to comply with the subcontract notice requirements. This was a case of Port Chester Electric versus HPE. So in this case, where the prime contractor's contract with its sub required the sub to tender certain claims in a timely manner to the prime, so the prime in turn could look at them, review them, and then flow them on up to the owner, the sub failed to meet the time requirements and its claim was rejected accordingly, and the court said, yes, you lose your right to make a claim if you don't meet the subcontract requirements. Now the next case I want to talk about is one called Aetna versus Abasco. In this case, the lead joint venture partner was found to have a duty to submit a claim to the project owner from its partner in a timely manner. So in this case, it really demonstrates that whether you're in a joint venture agreement and you have one party who is the primary interface with the government agency or project owner, or whether you're in a prime subcontract relationship and the prime is the only one that deals directly with the government or owner, these parties have a duty to timely obtain the subcontractor's claim, do a good ground review of it, and then pass it on up to the project owner in a manner that meets the time requirements between that are set out in the prime contract. Because if the prime fails to do that, then it cuts off the ability of the sub to have its claim considered. And this court held that that's almost like a fiduciary duty, that failure to timely move that subcontractor claim up to the owner caused the prime to have liability directly to the sub. Let's look now at site safety responsibilities. This will be lesson 13. Site safety is generally the responsibility of the contractor portion of the design builder. And the contractor has the wherewithal to manage the overall construction of the project and the safety programs on the project. Not typically the design professional doing those things. So I have put together previous videos and webinars on site safety and the responsibility of the project owner, the designer, the design builder, the CM, and the contractor as well as subcontractors. Rather than repeating all of that in the context of this design build workshop, I commend you just go and look at the site safety videos that are already available on my website and as YouTube videos. Next, we look at lesson 14, payment and licensing issues. The first case is Koppers versus Inland Steel. Estimates provided by a design builder to a project owner might be used as a basis for capping payments and creating potential liability. In this case, the design builder was liable to the owner for cost overruns when the job was estimated at $267 million but came in at $444 million. The court considered the bidding information showing that the contractor knew that more man days and cost would be required than it told the owner about. Expert testimony was presented to show the unreasonableness of the man hours estimated by the design builder. So in this case, without going back and looking at all the details in the case, apparently there was no guaranteed maximum price set. It was a cost reimbursable style contract, and the owner relied on an estimate in awarding the contract, but when that estimate ended up being significantly exceeded due to reasons that the design builder reasonably knew were going to occur and the owner didn't have the ability to know that, the court held the design builder liable to the owner for that cost overrun. The next case deals with licensing statutes being incorrectly asserted by an owner as a tool against paying its design builder. And this is Drew County versus Murray Company. And where a contractor's proposed to design build a hospital expansion, it performed numerous services before the hospital decided not to go forward, and then refused to pay for the partial design services as well as the preparation of cost estimates that were used in the guaranteed maximum price. The hospital then proceeded with a design bid build project or contractor, and it gave the contractor's design documents to a new design professional to use. In defending itself against the contractor's suit, the hospital alleged that the design build contractor had violated the law by not having a contractor's license before performing construction management, and had violated the law by performing AE services without a license. The court granted a summary judgment motion for the contractor because of several things, including the design builder did not construct or manage construction prior to receiving its license. The design builder's proposal to perform initial design and prepare cost estimates to derive a guaranteed maximum price for the hospital was not considered by the court to be a bid in violation of law. And the AE licensing statute didn't contain a penalty provision that would render the contract void. What it had were other provisions that would penalize the contractor in other manners, but not void out the contract. And finally, the design builder was not prevented by the statute from recovering under a quantum merit theory or promissory estoppel theory. So, since there was no written contract executed in this case, the court found that the design builder really needed this remedy of quantum merit and was entitled to make an argument for that type of recovery. Remember, we talked earlier about the fact that if you have a written contract, you can't claim quantum merit. It's one or the other. Written contract specifies how you get paid. If there is no valid written contract, then you can look at quantum merit to get what you deserve to be paid based on the quantum delivered. Next lesson is 15, ownership of plans and specifications.